Establishing a trust is a little bit like building a fence with a gate around your home. It can protect your assets, but the trade-off is that there's a cost to building that fence, and there's also potential for it to be a little bit more cumbersome. So today, we're going to dive into revocable and testamentary trusts and the trade-offs in establishing them.
Yeah, so Spencer, we're going to be talking about testamentary and revocable trust. Those are two different types. There's a lot of different types of trust, but those are the two that we're going to focus on today. We're going to go over some of the benefits, some of the cost, some of the reasons why you would maybe want to establish one, and maybe why you would not. So let's just start off with a brief overview. What is a revocable trust?
A revocable trust is a legal arrangement where you are transferring assets into this trust to be able to protect them. You can revoke it. So as long as you're alive and you're cognizant, you can make changes to that typically quite easily. And the idea is that it has some protections when you put those assets into the trust. Now, a revocable trust, as we'll talk about further, there are some things that it doesn't really protect against, but there are some helpful things that it can do, and particularly with respect to probate. Now, in our presentation today, we're not really going to dive into states' laws outside of the state of Tennessee, but suffice to say, if you live in one of the northeastern states or one of the western states, probate can be much more onerous and much more costly. So a revocable trust can be much more attractive from a cost standpoint there, because you might be giving up 5% of your estate just because of state laws in how you go through probate. That's not the case in the state of Tennessee.
Right. Okay, so how's that different from a testamentary trust? What's a testamentary trust?
So a testamentary trust is a trust that is established by your will. So it's not going to come into play. You're not going to fund that trust until you pass away. The interesting thing about a testamentary trust is that it is revocable until your death, and then thereafter it's irrevocable. So it's an interesting type of trust, and it has particular advantages in some circumstances, but it also has limitations because it's set up under your will. So it's not going to be a trust that you actually fund prior, whereas a revocable trust, oftentimes you would fund that soon after you set it up.
Okay, so it seems like there's a little bit of similarity, but a lot of differences as well. So what are maybe some of the advantages of choosing a revocable trust versus a testamentary trust?
Well, let's talk revocable trust and what they really help us with. Avoidance of probate, we talked about that. It is a private document, and so if you wanted to be able to pass on your resources to your loved ones, to different charitable institutions, and not have that be public in the probate process, then that can be one of the advantages. You completely bypass probate if you do it correctly and you fund the trust correctly. There's flexibility. So you can put those assets in over time. You could remove those assets if you wanted to. There is a level of, as well, help when we think about a revocable trust in certain circumstances. If there's incapacity and you name a successor trustee, that can also be quite helpful, because if that successor trustee steps in and can manage those resources in your stead, there's an opportunity there to make that seamless and not even have to go through some of the challenges of setting up a power of attorney and getting that recognized by different financial institutions. So a lot of different pieces to that.
Okay, that sounds good. It seems like that can be complex, though. Setting up a revocable trust where you can put stuff in, take stuff out. What's maybe a disadvantage of a revocable trust?
Well, there is a cost to it. So you work with an attorney and you draft that document. If you want to update that document, then there's a cost to that as well. There are also trade-offs in terms of the difficulty in putting resources into the trust, and it's not something that's a hurdle that's impossible to overcome, but we do have to recognize that there's a process of moving, say, real estate over to the trust. You don't just sign the trust document and then everything magically happens. You actually have to retitle your assets so that the trust owns those assets. And sometimes it's easy for people to forget some of those things that they actually need to be retitling, or get those beneficiary designations correct with some of their retirement accounts. So there is a level of complexity that we have to recognize, and we need to make sure that we've set things up properly for it to work the way it's intended.
Right. Well, and one of the other disadvantages of a revocable trust is, though you've gotten the assets out of probate, they're still subject to estate taxes, because they're still going to be included in your gross estate. So if you're surpassing those estate tax thresholds, either from a federal level or a state level, those are going to be included in your gross estate.
One of the other things that sometimes people don't realize with a revocable trust is it doesn't give creditor protection. So something happens and you're in an accident on I-40, or someone sues you or your business, you're not getting protection with that revocable trust. Same thing with a special needs type of situation. You're not going to be able to have benefits from the state unless you make a special needs trust irrevocable, which we'll talk about in a different episode. So there's some things that really a revocable trust is not going to be able to help with, but in terms of keeping everything moving in avoiding probate and being able to take care of you during your lifetime, should incapacity happen, it can be quite helpful.
Yeah. Okay, so let's jump into testamentary trust now. We've talked a little bit about the advantages and disadvantages of a revocable. What are maybe some of those advantages of a testamentary trust?
Well, testamentary trust really allows you to speak beyond the grave. And that's what most people use it for, whether they want to pass along resources to a beneficiary or a charity, but they don't want to do it all at once. So you may have a son or daughter or grandson, granddaughter, or some other loved one that just doesn't manage money very well. Well, you put those resources into a testamentary trust that is set up under your will, and it's funded as assets move through that process. And then you can say, well, I'd like these resources to be dispersed over the next 10, 15, 20 years or even longer. So that's a typical use of a testamentary trust. You're not avoiding probate in this because the will's got to be probated, but you do have some nice features in being able to continue in that. At the same time, you've got a complete ability to be able to revise that over time just as you revise your will. So you're not setting anything in stone there until you pass away.
Yeah, so Spencer, you were talking about revocable trust earlier, and you were saying one of the benefits is that it does avoid probate. That's something that a testamentary trust can't do. Similarly, part of the privacy concerns about going through probate, that's something that is a testamentary trust. Because it's in your will, it goes through probate, and then it becomes public again. What are some of the other disadvantages that we could see with a testamentary trust?
Well, and even clarifying, we want clients to work with an attorney to help them parse through whether they really want assets to go through probate. Oftentimes, with a trust, they're not going to, with a revocable trust, and that can be quite helpful because of the privacy issues that we talked about. But sometimes, moving assets through probate makes sure that everybody gets on the same page, creditors are notified, there's a level of transparency there saying we have nothing to hide, we're going to settle all elements right here, that actually can be quite helpful. So there can be trade-offs as we think about that. The lack of flexibility really, once a revocable trust or once a testamentary trust gets into and is set up, it's harder to amend that. And that would be the same really with a revocable trust that's set up after the grantor passes away. Oftentimes it's difficult to amend that for good reason. So in both of those cases, there's some challenges with flexibility there overall. I think the biggest thing, though, is, as you mentioned, the probate issue. So in the state of Tennessee, if you work with an attorney to move assets through probate, you're going to pay them on an hourly basis or a retainer fee, typically. And that's going to be fairly modest compared to what we oftentimes see in other states who have different perspectives, different laws about how probate works. We've heard podcasts from attorneys from different states that justify somehow this 5, 6, or even 8 or 9% fee of moving an estate through probate. And granted, there could probably be some really complex and thorny circumstances where maybe that would be warranted. But by and large, our clients, that would be a tremendous tax on them. So we have to recognize, if we're in the state of Tennessee, we probably have more latitude, and some of the states where we have a similar setup with probate. For some other states, we'd probably say California, New York, Connecticut, others, it would be wiser in all likelihood to go through and set up a revocable trust.
Right. Okay, so let's talk about some of the big pitfalls and the critical errors that people make when establishing your trusts. And one significant one is failing to properly fund the trust. Talk a little bit more about that.
Yeah, so it's almost like we buy a plot of land, in the fence analogy that we started with. We buy a plot of land and we say, gosh, I'm going to build an amazing home on this. I have this view and I'm going to put a pool here and I'm going to have all of the different things. And the first thing that we do is we put a gate up with a really strong, a fence up with a really strong gate. But we never build anything there. There's no real value there. And it's the same thing with a trust. You could spend $10,000, $15,000, $20,000 on an incredibly complex trust. There are some trusts with respect to supplemental needs that they are very expensive to draft and they're worth every penny, but they may be 60, 80, or even 100 pages. If we don't fund that trust, then we are really not, we're not getting the value out of that. And you'd be surprised how many different times we see clients not take those steps. So part of what we try to do is make sure that we're working hand in glove with the attorney to say, how do we update the beneficiary designations? How do we update everything that needs to be, move assets into the trust, retitle them, particularly on the real estate side? There's some steps there.
Yeah. So another critical error is just not reviewing it. And we've talked about this with beneficiary designations before, but why is that such a problem?
Well, just think about it in terms of what we've seen the last few years with the Secure Act. Oftentimes, trusts were drafted such that you would have distributions that would come out over the lifetime of the beneficiary from an IRA. Well, now we have 10 years to take those distributions. So some of the trust language there really needs to be updated because it's not in that beneficiary's best interest. There needs to be more thought, and there needs to be even some asset planning, of what goes into a trust and what goes into a particular type of trust there, because laws change. So we need to review it from that standpoint. We also need to review it from a standpoint of if beneficiaries change or if there's updates in personal circumstances. Oftentimes there needs to be an update there, or just the simple thing, if you acquire another piece of property and your whole estate plan is that you're using that revocable trust, well, you need to not put that piece of property in your name. You need to put it as owned by the trust to keep everything moving. So there's a lot of different pieces that we have to remember going forward, and we need to review things because oftentimes every couple of years we'll find, we forgot on this piece, so let's update this.
So when we think about the parties involved in a trust, we've got grantor, the trustee, the beneficiary. Can you just lay those out a little bit? What are those?
So you have initially the grantor, the person or people who set up the trust and fund the trust typically. Then you would have a trustee, and that could be the same person as the grantor, but the trustee is the person who is managing the trust, is making the decisions. So with a revocable trust, oftentimes you have the first trustee that is the same as the grantor. At some point, though, you need a successor trustee because the intent typically with a revocable trust is that you're seamlessly moving assets to the next generation or to an intended beneficiary at your passing or at your incapacity. So you need to have a successor trustee that's set up, someone that you trust, because they're going to be managing all of the elements, the financial elements in particular, of the trust. The beneficiary would be the recipient, and oftentimes you would have a primary beneficiary, and then you might have a beneficiary that would come thereafter, a contingent beneficiary or successor beneficiary. So you can have multiple levels of successors in each one of those, and typically would on some level. But those would be the key pieces of that. And there's other language. We won't get too far into the weeds here, but there's other language that some attorneys will put in place that you might have a trust protector that in the event that a trustee resigns, helps the beneficiary be able to pick a new appropriate trustee. There's different ways that these documents are drafted.
Now, one thing we haven't really touched on is taxation and tax implications. So what are the tax implications of revocable trust?
And there's a reason that we haven't touched on it much is because you're really not getting a benefit there. As long as it's in a revocable trust, the assets there are going to, if you have investment accounts, for instance, that are in non-qualified resources, there's going to be a flow through to your personal tax return. If we go irrevocable trust, then it's a separate entity and it has its own tax identification number. But as long as it's a revocable trust, everything still flows to you in that.
All right, so one of the last things we want to touch on are some of the beneficiaries. When we think about some of the particular beneficiaries that can be named. Think about, can you unpack a little bit, maybe you mentioned charitable organizations, you mentioned special needs. Can you unpack those two about how those can be of special benefit from a trust?
Right, and this could particularly be really a revocable trust or a testamentary trust. Oftentimes it would be a testamentary trust that you would be setting up provisions of how distributions would be made, in particular for someone with special needs that might not be able to manage those assets. You would set a trustee in place and be able to manage those resources for the remainder of that person's life or those people's life. Similarly, with a charitable beneficiary, there are different ways that you could set that up where payments go out over a period of time. You have a trustee involved with that, or there could even be another type of trust that's set up by your will through that testamentary trust. So a lot of different ways that you can push resources either to a charity or an individual that might need some help over time, or there just may be spendthrift protection. So they may have be a healthy individual and have capacity to make decisions, but they just might not be decisions that you like that are made. And so you may put some speed limits on how quickly a trust can be used. And that's another one of the ways that a testamentary trust can be effective, or a revocable trust for that matter, that becomes irrevocable at your passing. You set provisions in place, and then the trustee knows the guidelines with which he or she can push resources out.
So Spencer, as we wrap up, we've talked about this idea of offense. We've talked about speaking beyond the grave with a trust. What are really the things that clients need to know as they consider, is a trust, revocable or testamentary, worth it for me?
Well, we've talked about probate, and that can be a very helpful way to keep things private, to reduce expense. The caveat that we always come back to when we think about a long-term use of a trust is that just like any kind of fence, gate, there are ways that sometimes people get around those. And we want to look at things and encourage clients to the extent that they can to do their giving while they're living, so they're knowing where it's going. At the end of the day, there are certain situations, if we've got heirs that really need a trustee in place, where it makes sense. But the encouragement would be, as much as we can, that we're not just building that bigger barn to be able to protect those assets in circumstances that they may or may not need to be there. We don't want to, oftentimes, we really want to encourage clients to the best of their capacity to work on building those relationships and having an impact during their years, because 30, 40, 50 years down the road, they're going to have a very difficult time speaking beyond the grave, even if there's a tremendous trust that's very thoughtful that's set up, because things change.
We hope you enjoyed this video about testamentary and revocable trust. The big thing here is Spencer and I, we are not estate planning attorneys. We can't draft these documents. You need to go to a qualified estate planning attorney to have these documents drafted. For our clients, we're willing to look over them, but we will only make suggestions that you go talk with that attorney to make those final decisions. If you like these financial planning videos, please share with a friend, and if you have questions, go to our website at SeriousRetirement.com. This content was provided by Retirement Planning Services. We are located in Knoxville, Tennessee. You can visit our website at SeriousRetirement.com. The information in this recording is intended for general educational and informational purposes only, and should not be construed as investment advisory, financial planning, legal, tax, or other professional advice based on your specific situation. Please consult with your professional advisor before taking any action based on its contents. Advisory services offered through Retirement Planning Services, LLC.